we will be done at 12:15. Welcome to the Health Occupations and Long-Term Care Subcommittee. We have 6 bills on our agenda. Some are returning friends and some are new. We are going to take the 3 bills that Lisa has been working on first, and then we will take Lindsay's 3 bills. So I'm going to tell everybody the bill order so that they know it in case they are only here on one bill. We're going to start with Senate Bill 440, which is the Workforce Commission. We are going to go to House Bill 544, which is the Residential Service Agencies Reporting Bill, which is also Senate Bill 600, Chairman Kelly's bill. Then we will move to Senate Bill 133, the State Board for Certification of Residential Child Care Program Professionals. Those are the Lisa bills. Then we're going to move on to 3 Lindsay bills, and I don't think we're going to be able to vote any of them, so they'll largely be for discussion this week. Number 4 on my list, which is the Health Occupations Board, Senator West's bill, Senate Bill 777. Followed by 1016, which is the athletic trainers dry needling bill, followed by, again, a return to the financial gratuities bill, which we need some more conversation on. So with that, let us chat with Lisa. We're going to talk about Senate Bill 440. Part of this is my bad. During the busy part of session, the Senate put some amendments on this bill that we did not concur with, but upon further reflection, I think most of them were really, really good. So we're going to go ahead and adopt most of those amendments, but make some minor changes to them. Lisa, do you want to sort of give us an update on what we have proposed? I think there's one change to what we have proposed, but let's start with what we have.
Okay, so this is an emergency bill as the Senate passed it. It establishes the commission to study the healthcare workforce crisis in Maryland. The secretary designates the chair, the state agencies represented on the commission staff the commission. The way this in the Senate, they have an interim report due by December 31st, 2022, and a final report by December 31st, 2023. So the Senate bill had some differences in the board composition. They, rather than having all of the health occupations boards listed, they are having the executive director from each of the health occupations boards. They limited it to the Board of Nursing, the Board of Pharmacy, the Board of Physicians, the Board of Professional Counselors and Therapists. The reprint that you have that's on page 12, in this reprint, we kept the executive director of the Board of Nursing, Pharmacy, and Physicians, but changed the executive director of the Board of Professional Counselors and Therapists to the dental examiners, and then also added number 14, which is the Maryland Department of Health's liaison to boards and commissions, or the liaisons designate.
And let me stop you right there, because I'm going to add that. So this is the conversation that we've been having. You know, the bill that we passed had the executive director of every board, which is a huge number of people for a commission like this. And we thought it would be unmanageable. So the Senate came back with most of the larger boards and then just the counselors among the smaller boards, which also didn't seem fair. So we're trying to address that by instead making sure the dentists are on there because they're one of the larger boards. So now all of the larger boards are represented. And then we would have the MDH liaison to the boards, who's Kim Link right now, represented there. And then the smaller boards have also recommended, or someone, I've been talking to a lot of people, so I don't want to credit this to the wrong person, but something we've done in the past in situations like this is language that says that one representative from the health occupations boards not otherwise named in the bill. And that way the smaller boards can all get together and appoint their representative, who will then, since they all communicate with each other, you know, bring in people as needed and manage the flow that way, which, you know, reduces by 10 probably the number of folks in this commission, but allows them still to have a voice. So I'm going to recommend that we make that change to the Senate amendments so that the smaller boards feel represented, because with the Senate amendments, they didn't. Does that sound amenable to the subcommittee? Delegate Krebs.
Yeah, I was just wondering why we didn't, instead of having executive directors, if we didn't say the board chair or their designee, only because the board chair is the policymaker, not the executive director. They're the administrative function. And if the board chair wants to send the executive director, fine, but the executive directors are more of an administrative person, I think, than the policymaker. So I wasn't sure why we specifically said that. Every board may be different and maybe they want to send their, it would give them more of a choice. I'm just not sure how we came up with that.
I don't have an answer to that. To tell you the truth, I'm thinking through if we were to change it to chair. I am a little bit concerned because it's all staff, agency staff on the rest of the commission. I'm thinking that that will cost more money. Evidently, that will cost more money. I don't know. I honestly, I don't know, but I like the idea of keeping the staff talking to staff. We have sort of agency people throughout this commission. As an executive director in the past myself, you don't do things without consulting with your board chair. So I know there's constant communication there, but I would just.
But you see where you says executive director or their designee. And listen, I get it, but it just seems to me they are the chairman of the policy part of it. And you just want to make sure. I mean, I just know for myself working between the executive directors and the board chairs, they have different interests. I'm just saying they
do have different interests. I totally agree with you, Deli Crabs. And I think one of the challenges is, we need to make sure that we have the executive directors of the boards working well together and understanding the scope of the problem and their place in the larger healthcare landscape. So I'm kind of invested in the idea of supporting these executive directors. I think that they really need that. They need to be part of this larger conversation. I think the board chairs have been pretty good at that, but it's not their full-time job. I need the person whose full-time job it is to be really committed to solving this problem. Delegate Cullison?
Yes, thank you, Madam Chair. I would agree because my experience with executive directors on all kinds of boards is they are the undergirding of the foundation and the operation of the boards. So while the boards themselves are doing the activities of the board and monitoring its service to members, it's actually the executive directors that are making sure the board is functioning in a way that it needs to meet its mission. And so it's important that they be there, and from my perspective.
We'll just have to agree to disagree on that. I mean, I'm not going to, it's not my hill to die on. We don't send our staff to vote for us. Sometimes we send them to meetings, but at the end of the day, the buck stops with the board chairs and they're the policymakers. So, or they just would give them the choice.
Delegate Saab.
Thank you, Madam Chairman. Do we have any idea what the turnover with the executive directors and our boards? With staffing, like with how often?
Some boards have a lot of turnover and some boards rarely have turnover. There's just no consistency. The counselors, for example, just lost their executive director and they had previously lost theirs not long prior. But other boards have had the same one for decades.
Right. I was just thinking out loud that do you think.
But the board chairs are turning over pretty regularly. I mean, that's a consistent.
Right.
Term limited.
Just for consistency and having the same person, if he's on the board or she's on the board, then they change over and you have to start.
Right.
Over.
The board is changing regularly. Yeah. This is, we did change the timelines with this. So it's I think they're doing an interim report within a year and a full report within 2 years. And it's going to be quick. And this is not entirely about the boards, right? There's so many other stakeholders on this. So I think that we'll be okay with the amendments this way. We are also, just so everybody knows, adding in on the Senate bill, the executive director of the Maryland Longitudinal Data Systems Center, which we put in on the House bill, but they didn't have. And we're adding in the language about other long-term care settings, primary and secondary schools, community health centers, and community-based behavioral health treatment programs, which we added in on our bill. And the language about pathways for veterans also. So
you still have a member of the community college. Is that still on there?
That's in one of the subgroups that's specific. We specifically wrote it in one of the so not a primary member of the commission, but one of the subgroups. Are folks okay with this? Anybody? Does anybody want to move the amendments? No.
Move the amendments. I think we weren't sure if we were done discussing.
I mean, we can only talk so much about a commission. At the end of the day, we want to see what the commission can do. We gave them a charge to look at some things. So hopefully we're getting the right people in the room. If we need to make some changes, we will. So the amendments have been moved and seconded. And just to be clear, there's a verbal amendment to the amendment, making that language specific about one representative from the health occupations boards, not otherwise mentioned. Any further discussion on the amendments?
Is the fiscal note, I'm sorry, I'm Chairman.
That's
Is
okay.
there fiscal note, or is this all done with existing staff? This is an unpaid commission?
I can't remember anymore. I feel it was minimal if it was something. I think it's jointly
covered-
staffed by, I'm sorry, Lisa? Oh,
So the revised fiscal note is saying in fiscal year 2023, it will cost $97,500 for contractual staff for the Maryland Department of Health, the Maryland Department of Veterans Affairs.
Is it every year or just the first year?
It's only 2 years, so that it's $97,500 in the fiscal year 2023 and $39,100 in 2024.
Okay. Thank you.
sure. Okay, any further discussion? So we'll put on the amendments. All in favor of the amendments, say aye.
Aye.
Anyone who's opposed, put your hand up. Okay. And the bill is amended.
Move the bill as amended.
Moved and seconded. Any further discussion on the bill as amended? All in favor, say aye. Aye.
Aye.
Anyone who's opposed, put your hand up. Looks like it passes unanimously. Thank you, team. Next up, we have an old friend, House Bill 554, Health Facilities Residential Service Agencies Reporting Requirements, which is also Senate Bill 600. I call this an old friend, even though we haven't discussed this in the subcommittee yet, but this is the follow-up to an issue we talked about quite a bit last session. I believe there are some stakeholders here on this bill. I'm looking to see. I see Dana Kaufman here. I don't know if Ann Seacott is here or not. There's just so many people, but let's hear from Lisa and then we'll see who's here. Go ahead, Lisa.
This bill requires each residential service agency receiving Medicaid reimbursement for the provision of home care or similar services by a personal care aide to report the number of personal care aides the RSA has classified as an employee and as an independent contractor. The amendments strike language regarding the reporting of personal care aides' pay rates and benefits, and instead require the Maryland Department of Health to submit an annual report to Finance and HGO on specified data that may only be an aggregate and may not identify a specified RSA.
Okay, so from what I understand, we have a consensus amendment on this bill. I have spoken with the stakeholders, but I would love for the subcommittee to understand sort of what is left in this bill now and why we're at consensus and okay with doing this. So I will ask first, I guess Ann Seacott is here, or I've heard Delegate Chi might be here. Delegate Chi, do you have anything you want to add?
Oh, thank you, Madam Chair. I just want to thank the committee for considering this with amendment. And I want to especially give a shout out to both Ann and Dana for working hard to figure out a reasonable compromise. I think what comes before you now is a very small ask of the RSAs to share some data so that we can, one, better position ourselves for potential federal funding on this national crisis that the federal government is trying to address. And just in today's New York Times, there was a long article about this. So let's get ready for that. And two, it's a huge help for the state government to be more intelligent in setting rates and setting policies, because we don't know what we don't know. With that, I just want to thank you.
Thank you. Let's hear from Ann Seacott. Can you, Ann, explain to us what is left in the bill with the consensus amendment?
Absolutely. Thank Thank you, Madam Chair, members of the committee, and CCOT representing the Public Justice Center. David Rodwin is also here. He's really the expert. We're very appreciative of everybody coming together, and we went back and forth with numerous amendments, and you'll see there's a lot of stuff struck out of the bill. We've taken out a number of the data points that were required to be reported. The one data point that remains is the worker classification, and it is just knowing the numbers for each of the RSAs, how many employees are classified as employees and how many are independent contractors. And then that information, along with the other reporting that the reporting bill you passed last year, will be going into an annual report that the health department will look at to try to better calculate or at least try to calculate what an appropriate reimbursement rate is for home care services. Because as we've said before with this problem, yes, we have a workforce that is terribly underpaid. We also have service organizations that do not get reimbursed what it costs to provide the service. So we need to be uplifting both. And we think the bill now is amended, the amendments that you have before you will accomplish that.
Excellent. Thank you. Let's go to Dana, and then we'll see if Dave has anything he wants to add as well. Dana?
Thank you, Madam Chair, members of the committee. For the record, Dana Kaufman. And laid out the amendments very well. We appreciate working with them as always. And again, we just support the amendment. I don't need to go into much more detail than that.
Okay, thank you. Dave, I'm sorry, I can't see your little box, but I'm sure you're here. Dave Rodwin, anything you want to add? And then we have a question
Thank
from
you.
Delegate Lewis. Go ahead.
Thank you, Madam Chair. Yeah, just nothing to add substantively. Just want to thank members of this subcommittee and Dana and Delegate Chi, of course, and look forward to making some progress on home care job quality with this bill. Thank you.
Thank you so much. Delegate Lewis.
Thank you, Madam Chair. Thanks again to the bill sponsor and all the panelists. I just want to make sure, is Maryland going to be in a stronger position to compete for federal funds for healthcare workforce if we pass this bill? That's a yes or no. Will we be in a better position? Whoever's best to answer that, maybe Delegate Chi. See you nodding. Delegate Chi says it puts us in a better position. I believe her. Okay.
It's a necessity to qualify for federal funding. Thank you.
All right. Thank you so
Excellent.
much.
Delegate Krebs.
Yeah, maybe Dana could explain, how does this information differ from what the bill we passed last year in 2021 that we did? I remember we had a lot of negotiations about that. What additional information is coming from this that has not been done in the 2021 legislation?
Sure. This bill kind of narrows the information down like one more level. So the bill last year requires upon licensure and every 3 years, because we have non-expiring licenses, for the residential service agencies just to indicate whether or not they use independent contractors. This will actually now require information regarding the level of independent contractors versus W-2s that are used. So this does not, will not provide information as per which RCAs are using, but overall in the industry, how many of the personal care aides are independent contractors versus W-2s. And then the bill also, again, and this has been an issue we've been so concerned with for a number of years, does require in that report, again, a review of the reimbursement rates versus the cost of care, which it really is, I think, one of the most extremely important issues in bringing up this classification of workers, personal care aides.
No, the reason I'm asking is I remember, sorry for the noise, they're doing something out on the street behind us. I just remember last year being very carefully negotiated what we put in here. And I get irritated when we have another bite at the apple the next year when we reach consensus on a certain year. So you're saying this particular information will be acquired from the RSAs, but it will be cumulative. It will not be allowed to be distributed individually by RSA.
Correct.
It won't be subject to public information. It'd just be a cumulative data point for Department of Health.
Right. So they will know overall in the industry is the information that will be released.
Okay, thank you.
And I think, tell me if I'm wrong, but because I agree with Delegate Krebs that sort of another bite at the apple thing is, not what we want. We worked really hard on a compromise last year, but this is more of a refinement because now we know a little bit better what will be useful and helpful to lift all boats, something to that effect, right? I'm seeing some nodding. Okay, super. Any more questions? All right, and so we need to see if someone wants to move this amendment.
Move the amendment.
Second.
Moved and seconded. Any further discussion on the amendments? All in favor say aye. Delegate Lewis, your hand is up, but I think you like the amendment, so I'm going to assume it's unanimous. Any further discussion on the bill as amended? Any other comments or questions? Anyone want to move the bill as amended?
Move the bill as amended.
Second.
Moved and seconded. Any further discussion? All in favor say aye. Aye. Okay, and we're going to actually go through this again because we have to do the Senate bill. Everyone said aye, nobody's opposed. Delegate Lewis, put your hand down so that we don't accidentally mark you as opposed. So I guess we have to, Lisa, do the same thing for Senate Bill 600.
Yes.
Okay, so we're gonna put the amendments on. I'm gonna move the amendments.
Move the amendments.
Second. Second.
Seconded. All in favor say aye. Anyone who's
Aye.
opposed? It won't be, none, okay. On the bill as amended, I'm gonna move the bill as amended.
Second.
Anyone who, all in favor say aye. Anyone who's opposed, raise your hand. Good, it passes unanimously. So both 554 and 600 have passed unanimously and in the identical posture. What's next? Oh, okay. So Senator Washington's bill, which is a cross file of Delegate Collison's bill. Is that right? Delegate Collison, you had this bill, if I remember correctly? Maybe I'm making that up. The
No,
state board.
you're not making it up.
Okay.
Yes, Madam
Okay,
Chair,
good.
that's a cross file of my bill.
I forgot to ask you before subcommittee, we have this amendment that I think was not on your bill. Are you okay with that amendment?
I am okay. Yes, Senator Washington contacted me about the amendment. So yes, I'm fine with
Perfect.
that.
So Lisa, do you want to just run us through the bill again and the amendment, and we can hopefully get that amendment on and keep it moving? Because this bill, if I remember correctly, passed unanimously, right?
Yes.
Perfect.
So this bill alters the membership of the State Board for the Certification of Residential Child Care Program Professionals by reducing the number of members from 12 to 11, repealing the requirement that a member be appointed by the sub-cabinet, and repealing the requirement that and this is what is the difference between the Senate bill and the House bill, is that this bill repeals the requirement that a board member be a U.S. citizen. The bill also repeals the requirement that the board adopt an official seal.
And then I did a little looking into this US citizen stuff. There's only, it rarely appears in any other statute. There's a couple of random things, maybe 3, but generally speaking, that's not a standard language we have. So that's what the amendment would do. Does anybody want to move the amendment?
Move the amendment.
There's no
Looks like-
amendment to be moved.
Oh, the amendment is on the bill already. Oh,
Yes,
right.
Oh.
Thank you.
Never mind.
So we would need them to put the amendment on Delegate Collison's bill. The
Yes.
question is, do we take this out? Well, now I've drawn attention to something for no reason. Hi, Delegate Saab. I see your hand up. What can we do for you?
Just a quick question because it went by fast. So
Yeah.
what does the amendment do again? Does it remove the requirement or add the
It
requirement?
removes the requirement that someone has to be a US citizen, which is not a standard requirement. We don't really know how it got there. It doesn't appear in almost anywhere else in the statute. And I think residential childcare in particular is a space where you have a lot of immigrants who are working legally, but not necessarily US citizens.
So does it require residency, any residency requirement?
There's no requirement. It would then be just silent on it.
Okay, thank you.
Delegate Krebs.
Yeah, and I'm not really concerned about being a US citizen. My question is, are they here legally? I would assume, and I'm not sure if I'm right, that anybody in any of these professions would have to be legally in the country or else they're committing fraud. But that doesn't mean you have to be a US citizen. So I don't have a problem with this language. I'm just assuming that maybe council can get back to us about the other boards and commissions. Again, it's an assumption that I
Yeah.
would.
We looked it up. I think the library looked it up for us, and appears like in 3 random generally, like, hundreds of boards and commissions do not have this requirement.
No, I agree. I agree with the US, like I said, the US citizen, it's about being here legally. And there's a huge difference in that. Thank you.
Sure. Delegate Collison.
Just to, thank you, Madam Chair. The board members are appointed and they're vetted, right, by the governor's folks. So I would, maybe it's incorrect to assume, but I would assume that they would be checking for status.
I would go further to assume that if one were not here legally, they would not be highlighting that by applying for a state board position.
Yeah, there would be that too.
Right.
Thank you, Madam
Seems
Chair.
like not a smart thing to do.
No.
Okay, so it sounds like people are okay with this. There's no amendment to put on. I'm sorry for my snafu there. It's that time of year. So we
the
just
bill.
need someone to move. Perfect. Moved and seconded. I'll second it. Any further discussion of the bill, which has no amendment because there's no amendment on it? All in favor, say aye. Aye. Anyone who's opposed, put your hand up. Looks like it passes. Delegate Morgan's going to be opposed.
Let me do a little bit more research. I'm still, the conversation we just had, I'm still thinking about.
Okay, and it might be, I wonder if, Lisa, if we can get some sort of factual, there's a very important distinction between to Delegate Krebs's point, folks who are here working legally and should be able to serve on boards and commissions, and folks who are not here legally. So there must be some sort of process or some safeguard we can point to. We'll see if we can
I
find
can
something
try
more.
to figure that out.
Okay, sorry. I know nobody needs any more on their to-do list, but for now, Delegate Morgan will be a no vote. What is next? That's it for Lisa. You're free to go. Go research and find us an answer to Delegate Morgan and Delegate Krebs' questions. Moving on to the Lindsay bills. So we have 3 of these. We're going to start with Senator West's bill, which I believe, and I was in finance at the time, so I haven't watched the hearing, but I hear the hearing was pretty simple, but we have since heard from a number of the boards who have a bit of concern on this bill. So Lindsay, why don't you remind us what the bill does, and then we'll see what stakeholders we have here to talk to us about it.
This bill authorizes a licensee, certificate holder, or registration holder who is subject to an investigation by a health occupations board that may result in charges or sanctions to be represented by counsel during the investigation and have counsel present to participate in any interview conducted by or on behalf of the health occupations board during the investigation. Counsel may ask questions of the represented party, ask that a question be clarified, provide advice to the represented party, and provide information relevant to the investigation on behalf of the represented party. A health occupations board or agent of the board may exclude counsel from an investigation or interview if there's evidence that counsel is substantially interfering with the investigation or interview and violating the rules of professional conduct or acting in a manner that is prejudicial to the administration of justice. This bill didn't have a cross file. The vote in the Senate was unanimous on it. I wanted to note that there were a number of pieces of written testimony submitted on this bill that appeared to be favorable with amendments, including Senator West's testimony on the bill, but most of those amendments were incorporated on the Senate side. They were submitting the same testimony that they had submitted to the Senate committee, with the exception of the dental board's testimony and I don't know if anyone is here from there, but their suggested amendments weren't exactly adopted. They had concerns about the licensee cooperating with the investigation. And so I think that maybe the spirit of those was attempted to be incorporated by the Senate with the language about interfering with the investigation. And then there was, as you mentioned, some opposition from the various other health occupations boards.
Excellent. So do we have anyone here from Senator West's office? I don't think so. I just want to make sure. I am pretty sure we have someone here from the dental board because they reached out. Is there anyone here from anyone who wants to speak on this bill? Put your hand up. Aye. Hi, Matt. Good old Matt. At least he showed up. Maybe he can tell us what's going on. Anybody else here who wants to speak on this bill? Perfect. Dan.
There's some physical hands going up, but
Really?
they're not putting up their little electronic hands.
Okay.
I hear Edwin Morris is here. Okay, let's start with Matt Dudzik since he got his hand up first. Then we'll go to Ed Morris and Dan Doherty. Go ahead, Matt.
Sure. So I know you said that you were not at the hearing, but for those who were at the hearing yesterday, I do want to correct some of the statements that came up at the hearing. First and foremost, I believe that Senator West was very much mistaken with the claim that the board frequently excludes counsel. As far as I've been able to tell, the board has never excluded counsel from an interview. And I think that's really important to be considering as a baseline when looking at this. The closest thing to that is that in a few instances where counsel has consistently disrupted an interview, we have advised them that if they continue that behavior, they may be asked to leave.
2:30.
That's it. As far as I'm aware, that has always been enough. But I mean, that's our only tool for actually dealing with unruly counsel, and this bill would take that away. Again, these are not hearings. These are not depositions, where an objection or an interruption could be ruled on by a judge. We have no issue with counsel attending an interview. And if the bill simply said, licensees may bring counsel to interviews, counsel may advise them, we would have no issue with it. But the bill actually makes them an active participant. There is some language for excluding counsel, but it's such a high barrier for doing so that it might as well not exist at all. Really, the overall issue is that the bill gives counsel an avenue to significantly delay or derail investigations before they ever even reach the charging stage. Because again, these are fact-finding interviews that happen pre-charges. When the cases end up inevitably going before the Office of Administrative Hearings, it gives them the avenue to shift the focus from whether or not the physician violated the Medical Practice Act, and instead debate on whether or not the board properly allowed for counsel participation. Even if the end result ends up being that this physician still faces discipline, you have now significantly extended the investigation and its resolution, which is, that's great for the doctor because they can continue practicing while all of this is going on. It's certainly great for their counsel, who gets a lot more in the way of billable hours. But it's not great for the complainant, who is now waiting for months and months to see any kind of resolution. And it's certainly not great for the patients who are being served by a potentially dangerous healthcare practitioner while a case sits in purgatory. So again, it is a very innocuous seeming bill, but we have serious concerns that it would enable bad actors, and they do exist. These are not theoretical bad actors. We have counsel that has disrupted interviews more than 30 times. We have counsel that has prevented our inspectors from inspecting a facility until counsel arrived. While the inspector's been waiting, and they actually had to contact law enforcement to gain access, they could hear people shredding documents and cleaning the office before they were allowed entry. So, these are not hypothetical concerns. We do not want to enable this. We already allow counsel. We don't believe this bill is necessary.
Thank you. Let's hear from Edwin Morris. Hello.
Hello there, Madam Chair. Thank you very much for allowing us to be here today. I think Matt just read my testimony, quite frankly, but I want to point out, particularly when the dental board, our big concern is investigating issues, for example, of infection control, where public safety is at stake. And so what we do, we will conduct unannounced inspections. And the whole purpose of that is so that we can get a grasp of what's going on at the time when the inspector shows up, and to have a licensee say, well, I'm not going to let you in until I have my attorney here. Maybe the attorney can't be there until the next day. These are very serious impediments to a proper investigation. And I think that it permit that, number one. Number two, we don't, for example, have a situation if we're interviewing somebody to control what the attorney, for example, if an attorney objects to something, we don't have a judge, we don't have anybody there that can rule on the conduct of the of counsel. And I think that this bill, I know we're late in the game in discussing this, but I have very serious concerns about it. We do permit counsel at interviews, proper interviews. An inspection is not an interview as far as we're concerned. And I think we would compromise the safety of the public if we permit a bill such as this to go through. It has a lot of broad implications, and it's very difficult to enforce from the standpoint of the state board. So that's my comments.
Thank you. Let's hear from Dan Doherty, and then we'll hear from Karen Evans. Go ahead, Dan.
Thank you, Madam Chair. Dan Doherty here on behalf of the Maryland State Dental Association. We support Senate Bill 77, but we do think that there are some concerns that the boards have that are legitimate. When the bill was heard in the Senate and before the hearing, I spoke to the sponsor and indicated that we felt counsel should not be able to come in when there is an unannounced investigation in an office. You all may remember in connection with the bill that was in dealing with training and disciplinary hearings that you all voted, that one of the reasons Senator Bidel put that bill in originally was because of a doctor in Anne Arundel County that the board could never get information on. He would close up his office or he wouldn't be there practicing. And now they have the ability to go in unannounced, and if he will not cooperate, they can at least go in and look at the records. It would be horrible if he could, a dentist, he or she could bring everything to a halt and say, I'm going to call my lawyer. So we think to a degree the investigation should be outside the scope of this bill. Secondly, I do think a valid point was made that the provisions in the amended bill dealing with on page 2, lines 21 through 29, that's a pretty high burden. I would suggest that if you're going to take that approach, you would do a C 1, 2, and 3. So it would be substantially interfering with the investigation or interview, or violating the rules of professional conduct, or acting in a manner that is prejudicial to the administration of justice. Those things would provide more clarity. It would be more susceptible to the boards being able to manage it. But we do support the bill in concept. We do think a licensee, certified practitioner, all should have the right to counsel at the appropriate times during the interview investigations.
Thank you. Let's hear from Karen Evans.
Good morning, committee members. In line with Matt, we feel the same way. We already allow attorneys to come in. If I can just have my lead investigator to give you a brief point from their point of view. Is that okay, Delegate Kelly?
Of course, yeah, absolutely. It's
Sarah,
helpful.
can you please? Thank you. Sarah, can you please speak to the committee?
Sure. Good morning, everyone. And Madam Chair, thank you for giving me an opportunity to just discuss investigations at the Maryland Board of Nursing. We already give anyone that's under investigation the opportunity to be represented by their counsel. And we, collaborate with counsel once we have a letter of representation on file. From our history, we have never denied anyone representation during the investigation stage. And pretty much in our investigation stage, we're just doing fact finding around the allegation of the complaint. And it's giving the respondent an opportunity to provide further information regarding the allegation. There's no decisions making any decisions of the complaint at that time, and they will be given a further opportunity later in the investigation phase. But at that time, we're just gathering information. This bill would significantly hinder us in our investigative phase, especially when we're gathering information. It may potentially delay the investigation by us finding other ways to gather the evidence needed to support or refute the allegation itself. But they are already welcome to have representation, and we just have a letter of representation on file for them.
Okay. We'll go to questions in a minute. Karen, did you have anything else to add, or we'll go to Sarah Peters next?
And also just, yes, one more thing. All of our investigators go through bonnet training, which is investigative training for the Board of Nursing. So I just want to let you know that it's not just we just put someone out there, they actually have the training, and half of our investigators are nurses and the other half are non-nurses, and they usually take the non-nurses usually take the lesser cases where the nurses take the more serious cases. Thank you.
Very much. Let's hear from Sarah Peters, which is the last hand I see up. Sarah.
Madam Chair, members of the subcommittee, Sarah Peters here on behalf of the Maryland Podiatric Medical Association and the Nurse Practitioner Association of Maryland. We are in strong support of Senate Bill 77 as amended. The interview process, as you can imagine, is the opportunity to defend against any allegations of the licensee, and it could result in ending one's license, et cetera, and not to mention the reputation that will result from any of these allegations. And so we do support.
Okay, excellent. Do we have questions for up? I see already a hand up from Delegate Collison. Go ahead, Delegate Collison.
Thank you, Madam Chair. I guess I'm a little confused because what I'm hearing from the boards is that they do allow lawyers to attend the investigation or participate in the investigation. So, and exclude it, and they want to be able to exclude bad actors, but I'm not understanding that that's very often. So am I incorrect? Am I hearing that wrong? And that counsel is often refused to be able to participate, so that we need this kind of mandate? I don't know who can answer that.
Could answer that. I don't know if Dan or Sarah or someone who spoke in favor of the bill wants to try and answer that. Do you have examples of folks who had counsel excluded among your constituencies?
Madam Chair, am I muted or can you hear me?
We can hear you, Dan.
Okay. This bill was introduced by the senator at the request of the president of the Maryland State Bar Association. I don't think it was a Maryland State Bar Association's bill, but she is the one that requested it. And she testified about incidences where she was representing various healthcare providers, and there were problems with being able to be present and advise your client. I don't know what boards they were, but that was the testimony. I personally don't have any knowledge of people being denied counsel. There certainly are instances where they probably should have been, but and the investigation in the office is one of them. But I don't have specific examples.
I did see Scott Tiffin put his hand up. So before we go to Delegate Krebs and Bagnall's question, Scott, did you have something to add to this?
I was just going to say, when I was talking to NASW about this bill, they didn't have any experience of anyone being denied counsel. But the question that a lot of those folks had was that they weren't always sure when counsel was allowed, or whether they were allowed counsel or not. So they just had kind of general questions about when they could have counsel. And so I think that was their interest in this bill, is just to kind of clarify whatever the rules are, just make sure they're clear to everyone, so licensees know. So just want to throw that out there.
Excellent, thank you. And I see Matt Dudzik put his hand up, unless that's just been up from before. Matt, did you have something to add on this as well?
Yeah, obviously I can't speak for the other boards. I know with the Board of Physicians, we were not able to find any instance where counsel had actively been denied. We found a small handful of instances where we advised counsel during the interview that if they continued to disrupt, they'd be asked to leave. In every instance, that was enough. The counsel then, kind of reeled themselves in a little bit. We had one instance where somebody attempted to bring a whole panel of attorneys. We told them that they would be restricted to 2 attorneys, simply because of the interview room is not a large room. We couldn't fit them all in. But again, we haven't been denying. And if this bill was narrowly focused on clarifying that a licensee was permitted to bring counsel with them to the interview, and then narrowed that focus to serving in an advisory capacity rather than making them an active participant, we would not be opposing it right now.
Dr. Morris.
Thank you. I'd like to comment on the fact that when we talk about interviews, maybe we need a better definition of an interview. But if we are conducting an unannounced inspection, the fact that it's unannounced has purpose. We want to be able to go in there, see what's going on. That I don't think constitutes an interview. And I would certainly say that generally attorneys are not present because it is unannounced. And I think that would very much impede what we're trying to do in protecting the public. So if, when we talk about interviews, a real interview between the board and the licensee, we always have attorneys there, and they can advise their clients, and I think that works well, but not when we're trying to particularly investigate cases when we have unannounced inspections. Thank you.
Thank you so much. We're going to hear from Delegate Krebs, then Delegate Bagnall, then Delegate Lewis. Delegate Krebs.
Thank you. It sounds like there's a lot of agreement here, and maybe we do need to put in law that to make it clear to people that they are allowed to have counsel. It seems like that's the practice of everybody. I do agree with Mr. Morris that it should not be during unannounced visits. That should not be included. That should be specified in there because that's part of the investigatory process. And I think the differences between the investigatory process and the actual charges that they have. So I think there's some common ground here about what I just heard. But the one question I had for Matt, at the very beginning, you talked about sometimes they could stretch out the time frame for the discipline because they were still practicing. But there are other times I know that we've had for different boards that people have not been able to act or not been able to practice while this is being investigated, and it's taken a really long time. So how does that decision made on whether someone can continue to practice or not? And how would that affect this?
So there are a couple of avenues that the board has. In a typical investigation and complaint, there are no restrictions to the license until that complaint is resolved. Now, the board does have certain avenues to take in cases where there is serious risk for harm, where we can pursue a summary suspension. But that is a separate process. In the vast majority of cases, the licensee is able to continue acting. The only time that there would be an exception to that, again, would be when there is a really, really serious violation going on that would pose a major active risk to the public.
Thank you. It sounds like there is some common ground here, and I think we can find that. It should not, someone that comes in should not be able to be dilatory to just keep pushing this stuff off. So that concern is something that you raised that is true. But I would hope that maybe the folks on here, we could get some additional language to make it clear what the role of counsel is and what it's not in this investigatory process that everyone could live with.
Okay, Delegate Lewis.
Thank you, Madam Chair. And thanks to all the panelists. I'm trying to understand what an investigation looks like. Because of course, we all understand due process, but we also understand the duty of the medical board to protect the public's health. So quick question. An unannounced visit, does that look like something we can all imagine, like a health inspector visiting a restaurant to check if there are health violations like rats and bugs and things? They show up, they walk in, they take a look, and they see how things are actually functioning in on an unsurveyed setting. Is that what's going on?
It looks like Edwin
There's
Morris.
like 30 experts on this call. Yeah. One of you can turn on your mic.
Ed Morris put his hand up. He's good.
I have never been in an inspection, in an unannounced inspection. I just have seen reports and I see what goes on. Generally, from the dental board's standpoint, you go to the front desk, you tell them we're from the board, yes, and want to address the issue at hand. Generally, they are very often infection control issues, which are very serious. We take these very seriously, and so they will ask questions. They will ask staff. They'll find out who's there, and who's in control of who the boss is and who's responsible for things. And I've, of course, never been at a restaurant inspection, so I don't know how that compares, but it sounds similar. But, and they take photographs and that sort of thing.
Would an
Okay.
inspection interfere with the ongoing activities of that office? Would patients stop being seen? Would phones stop being answered?
I am conjecturing here. I don't know. I would
Matthew
say that-
Dudzik, you don't know?
Pardon me?
It sounds like Matt Dudzik can answer. So
Okay,
let's hear from Matt.
Sorry. Yeah, and I actually have been on inspections, quite a few, because when I first started with the board, I actually started in a compliance role. So I've been on several inspections. In every instance, we have done everything we can to not interfere with the facility continuing to see patients. But we do enter. It is unannounced. We present that we are from the board. There's we have statutory authority to enter and inspect the premises. It depends on what the nature of the complaint is, but typically we will go through the office. We'll take photographs. Again, we obviously try to be respectful. We don't want to. The vast majority of complaints don't actually result in disciplinary charges. So we don't want to actively disrupt people receiving care from their doctors, but we do look at everything. We look at everything from the cleanliness of the office and infection control procedures to proper storage of medication, things of that nature, proper storage of records. There's quite a lot that we look at, and we may focus on something specifically depending on what the complaint alleges. But yeah, I do think the idea of it being similar to like a health inspection, we don't have a checklist in the same way that some health inspectors may, but it is similar in how we go about reviewing everything.
And last question, if I may, Madam Chair. So you're literally going in to visually observe activities, document what you see. There's no interview, there's no interrogation, there's no pigeonholing of a provider and demanding they answer questions. It really is more of as undisruptive a surveillance activity as can be imagined. Is that correct?
That is the general intent. There may be instances where we have to briefly ask questions of staff or those that are there, especially if we're looking for specific records or anything of that nature. But we're not bringing them
On a
in.
deposition. Okay. Thank you so much, Madam Chair. Thank you.
Absolutely. Last questions from Delegate Bagnall.
Thank you, Madam Chair. And this is just a clarifying question because I come from the summer camp world where we're always subject to inspection. We don't know when it's coming, but we know that it's going to happen. It's standard practice. Are these inspections standard practice, or are they only, is the trigger mechanism a complaint?
Matt, can you answer that?
It may be different for the various boards, but for the most part, it is something that is triggered by a complaint. We have over 45,000 licensees, so we just don't have the staff to do regular inspections. There are some cases where there are statutory requirements for inspections in certain periods. So for instance, dispensing permits for physicians came up previously. There are, pharmacy inspectors from the Office of Controlled Substance Administration that will inspect twice during the duration of that permit, things of that nature. But for the most part, these are not regularly scheduled inspections. They come up in response to a complaint.
Thank you. Excellent. Ed Morris, did you have something to add?
Just a comment from the dental board's situation. Virtually all of our inspections are a result of a complaint. We don't go out looking for problems.
Excellent. Thank you. So we're going to put a pin in this discussion for now because we have to move on to another bill. So we're clearly not ready to vote this. Let's move on to the athletic trainers bill, House Bill 1016. Lindsay? And this is also Senate Bill 711, which is Senator Byla's bill.
Yes. So the House version of this bill authorizes a licensed athletic trainer to perform dry needling if the athletic trainer is registered by the Board of Physicians. The board must issue a registration to perform dry needling to a licensed athletic trainer who meets specified requirements. There were amendments adopted on the Senate cross file of this bill, at Senate Bill 711, and Delegate Lewis Young has offered those amendments to match her bill to the Senate cross file, which I circulated those amendments to you all earlier. The amendments require a licensed athletic trainer applicant to be approved by the Board of Physicians through a specialized task designation on an evaluation and treatment protocol, instead of requiring the licensed athletic trainer to be registered. The amendment removes a course instruction exemption for dry needling practitioners who completed course work before 2018, and removes a registration exemption for dry needling practitioners who practice out of state. The amendment also removes a $500 fine and places disciplinary procedures for dry needling under existing disciplinary procedures for licensed athletic trainers.
Excellent. So this is the first time we're discussing this bill in subcommittee. We are not voting this today, so I just want to make sure everybody knows that. If you're a proponent here on this bill, if you could raise your hand in the Zoom so that you show up. I do see Bill Pitcher's name. I know he's on this bill. Delegate Lewis Young is here, so we'll start with her, and then any other proponents who want to speak, raise your hand. Go ahead, Delegate Lewis Young.
Thank you, Madam Chair. I'm not going to speak at great length about the procedure because you all have heard this bill twice before. Just quick refresher, dry needling is a procedure that uses a very thin needle to stimulate muscles and tissues that hands and fingers can't reach, and it's much quicker than massage. Why is this a challenge for us in our state? Because athletic trainers are limited in their ability to practice this technique, and our schools, universities, and sports teams are very limited in recruiting athletic trainers who are used to practicing this technique. In fact, 26 other states and the District of Columbia permit this. So this is very important to the Ravens, to the Oreos, and several of our major universities, University of Maryland, the Naval Academy, and Towson University all support this bill. I think there has been some misunderstanding about this bill, and I'm going to address that because I saw an email as recently as within the past half hour. The requirements for training are the same, if not greater, than other areas that practice this. You'll see right in your bill that at least 80 hours of training are required. And the bill goes into detail specifying who can do the training, what course material needs to be included in the training. There's really quite a bit of detail about training in the bill. So I want to end that misconception. The other thing I would like to point out, we have resolved difficulties with all stakeholders but one, and that is the acupuncturist. Not hearing any safety or training issues that haven't been addressed. In fact, we have safety data from those 26 other states and the District of Columbia who have documented that the side effects are relatively minimal. But in the bill, it says this is not performed for the purposes of acupuncture. So for those acupuncturists that have some turf issues, please read that sentence. I think I've pretty much covered the points that I wanted to make, and I'll turn it over to the subject matter experts.
Excellent. So I'm going to guess that's Jane Miraglia, because I saw your hand go up pretty fast. Yes, Jane, welcome.
Yes, ma'am. Hi, thank you, Chair. Thank you for allowing us to be here today, committee. We just want to talk about the bill really quickly. So I know Matt's going to touch a little bit more on the evaluation treatment process, but I want to talk about just my undergraduate education experience. So as an undergrad AT, we have a minimum of 1,800 didactic educational hours. And I believe Delegate Young, if not, someone had sent around the requirements put in the bill that for every person who's allowed to dry needle in the state of Maryland already. So what physical therapists have to go through to get licensed, what the acupuncturist requirements are, and what athletic trainers are. And in Maryland, over 70% of athletic trainers already have their master's degree. So that takes us up to 22,700 didactic hours only. That's not including our clinical hours. During my undergraduate experience, I also had an in-depth human cadaver anatomy lab where we would go through, dissect, look at the insertion, the origin, how the muscles connect to each other, how the nerves function to that. So on a physiological level, we are greatly trained on this already. In addition to that, I had over 2,500 clinical hours in my undergrad experience only. If you add in for what many of us have in our masters, that is even more. And so in Maryland, if I were to be able to dry needle, I would first have to pass either an undergraduate, or after this year, would have to have a master's degree, college degree. From there, I would have to be eligible to sit for our national exam. After I pass my national exam, I would then have to get licensed in whatever state I want to work in. So in Maryland, after I get licensed, I then have to have an evaluation and treatment protocol filled out with my physician. And from there, the physician then has to agree, after I already take the extenuating dry needling courses, pass all the requirements that are the same for physical therapists, chiropractors, doctors in Maryland, those same classes with those same people, then my physician has to agree to let me dry needle. Once we go through all that steps, it still doesn't mean I'm allowed to dry needle in Maryland. Then the company that I work for then will also have to agree to let us use that skill. And one step further is, with any medical procedure that's done by any medical professional, there has to be informed consent with the patient. So from that perspective, having to be under our physician's license and to have those approval, I'm sorry, that's my work, Lucky. We actually have more oversight that on us than any other profession does to allow us to dry needle. And that's all I wanted to touch on. We have Colin Francis here with the Baltimore Ravens, who was previously certified to dry needle, so he can answer anything more specific relating to dry needling for you.
Excellent. Let's hear next from Colin Francis. Welcome.
Hi, thank you guys. I really appreciate the time. I gave testimony in the Senate and the House, so I won't repeat it. I want to be here as a resource for anyone who has questions about athletic training, about dry needling specifically in athletic training. It's something that I've been certified for the last 5 years. And when I was the head football athletic trainer at Indiana University, I was able to use it on those football players. When I came back to my home state of Maryland, I was not able to use it with the patients that I see. One thing I do want to point out, though, is the only patients that I'm allowed to see as an athletic trainer are the ones that the team physician sends to me. So as an athletic trainer, they're first seen by the team physician. The team physician evaluates the injury with our help and sends to any kind of MRI, X-ray surgeon. If they say, hey, treatment and rehab is the best option, they turn them over to me as the athletic trainer. And that's the only patient that I'm allowed to see. Nobody can come off the street and see me as an athletic trainer. I can only see the ones the team physician assigns. And the team physician is the one who dictates the level of care. So all dry needling that I did in Indiana was under the direct supervision and direction of the team physician. So there's always oversight. There's always safety measures in place. And that to me is huge, because it really isn't a turf war, because I can't see any of the people that any other provider is seeing. I can only treat the athletes that my team physician sends to me. So if you have any questions about athletic training or dry needling, I'd love to hear them. I'd love to answer them, or even the Ravens. I love to talk about them.
Great, thank you. Do we have any other proponents here who want to say something on this bill before I go to questions? I don't see any more hands up.
Delegate Kelly, if I can interrupt for 1 second. My counterpart, Ed Strapp, is actually traveling back from the Junior World Championships with one of our Olympic teams right now. And he just asked that on his behalf that I request that you guys take this favorably. And as the athletic trainer for our Olympic teams, he is bound by our state practice act here in Maryland. So even though he's going to Italy with our teams, he can't perform all those same treatments that team members who come from other states are allowed to receive as well. So thank you.
All right, thank you for that. Any questions from the committee? Don't see any. There we are. Delegate Saab, go ahead.
Thank you, Madam Chair. And just have a quick question to Colin. Thank you for explaining the process. I'm not sure if you can answer that, but how would that apply to, because I know once athletic trainers can do dry needling or anything. They're also in high school events. So will they be, how would it work there? And I don't know if you can answer that, but how would it work?
Sure. Well, in Maryland, not every high school has an athletic trainer, unfortunately. I wish they did. We don't protect all of our kids the same way as other states do. So a lot of high schools don't have athletic training services, especially look at Baltimore City. No high school has athletic training services. So not every athlete is protected by an athletic trainer as they should be. Then if you're dealing with somebody who's under 18, everything has to go through the parents. So a high school athletic trainer cannot dry needle a high school athlete without permission from the parents and without being seen by a team physician, referred to them for treatment by the physician. So the physician oversight doesn't change for a high school athlete, but the parental oversight does. So in order for them to dry needle a high school student athlete, they would first have to send them to a team physician or their own personal physician. The physician would have to evaluate the injury and present the diagnosis and develop the treatment plan. If they found that dry needling was a part of the treatment plan and the athletic trainer is certified in dry needling and if this bill passes and it's an approved specialized task as part of their evaluation treatment protocol, then that athletic trainer would have to turn to the parent. Same as if they were going to do any kind of treatment, it all would be under the parent. So an athletic trainer dealing with someone who's under 18 still has to get parental consent and team physician oversight.
Thank you. I appreciate the answer. Thank you, Madam Chairman.
Before we go to Delegate Bandari, I'm just going to let the stakeholders who are waiting for House Bill 462 know we're not going to have time for this. I am already losing members and we were supposed to end 15 minutes ago. So I apologize. We will take you up at the next meeting. Let's hear from Delegate Bandari.
Thank you, Madam Chair. Thank you, Colin. To perform dry needling, a physical therapist must register with the State Board of Physical Therapy examiners, right? And they have to have a appropriate education, I believe 80 hours of total specified instruction, 40 hours of practical, I guess, and the individual must be licensed by MPD. Based on your experience, could you give us the comparison and contrast about the experience, about the knowledge that the committee will have, the total kind of experience and knowledge what we are doing here?
For sure. And athletic training and physical therapy, although they overlap a little bit, like most allied health professions, are very different jobs, right? We are experts in acute care. We are experts in emergency management. We are experts in athletic injuries. If someone were to have a cardiac issue or a stroke, me as an athletic trainer would not be the person to send them to. They need to go to a physical therapist for advanced rehab. So that's one thing to incorporate. Athletic trainers do a lot of the acute care of the injuries. You see us in the fields and the sidelines, and we do rehab. Physical therapists, although some of them may be athletic trainers, a physical therapist alone is not seen on the field doing evaluation and acute care. Now, as far as dry needling education, the class that I took was filled with athletic trainers, physical therapists, and chiropractors. So I took the same exact course as physical therapists did that are allowed to do it. One of the biggest companies that provides this dry needling education is called Structure and Function Dry Needling. They have advanced classes, they have intro classes. Those are run and taught by athletic trainers, but it's for physical therapists, chiropractors, and ATs. So the 80 hours of work and the 40 hours of support afterwards, observed hours, is all the same as physical therapists and athletic trainers. Now, the athletic training company actually put a research study out that said entry-level athletic trainers are actually more prepared because of their undergraduate education than a physical therapist would be for this job. So as part of our undergrad education, we get a broader base of the skills needed than physical therapists do. So we are actually more prepared for the course than physical therapists are, even though we are not allowed to do it in this state yet.
Thank you.
Okay, I don't see any more questions for the proponents. I know we have Haley Evans here to talk in opposition to, and Matt, are you, Matt?
I just wanted to provide some clarification. We're not for or against the bill overall, but I did have a couple of relevant points just as the entity that's kind of overseeing.
Okay, awesome. Haley, are you here? I think you're here. I'm very
I am.
confused. Okay,
I
so
am. Thank you, Madam
let's hear
Chair.
from Matt first, since he's just clarifying, and then we'll hear from you. Go ahead, Matt.
Yeah, and so the Board of Physicians, I mean, we generally do not take a position on scope matter. So we are not taking a position at all on whether or not it is appropriate for this to be within the scope of practice of ATs. Did just want to clarify 2 points. The first is how that evaluation and treatment protocol works. I think Mr. Francis touched on it a little bit, but an evaluation and treatment protocol is the guiding document that an AT must operate under. They are not actually restricted to just athletes. That was actually expanded in 2020 to athletic individuals, but they must operate under the evaluation and treatment protocol, which does provide limits on who and how they can provide services. Regarding the amendments, which make this a specialized task, I did see the delegate forwarded an email that implied that making it a specialized task removed the oversight of the education process. And I do want to clarify that right now, the way the specialized task process works is that when you are completing or modifying an evaluation and treatment protocol with the board, which again, that's the guiding document, you must describe any specialized tasks that the supervising physician will be delegating to the athletic trainer that essentially go beyond the core training of an athletic trainer. And that has to include documentation of competencies, certification, credentials, and other requirements. And that gets reviewed first by the athletic trainer advisory committee and then by the Board of Physicians itself. So it is still a verification process of those credentials. It just is not called a registration. I just wanted to clarify that. Again, you know, it's whether or not they should be able to do this is sort of beyond our purview, but I wanted to just make those 2 points clear.
But yeah, the first point you made, I think, was important to me because I was remembering that as well. We expanded to athletic individuals. So, right, I do remember doing that. Thank you. Okay, let's hear from Haley. Go ahead.
Thank you, Madam Chair and members of the subcommittee. Haley Evans here on behalf of the Maryland Acupuncture Society. And Madam Chair, in the interest of the subcommittee's time, may we have Dr. Denise Tyson give our remarks?
Sure,
She is
absolutely.
also on. Thank you so much.
Hi, how are you doing?
Hi, go ahead.
Thank you. Okay, well, I just wanted to start by saying that, you know, in all of us reviewing it, the bill, we've heard around in many of the different hearings about a turf war. This is not a turf war, first of all. Acupuncturists, from our profession, we're not in competition with anyone. We practice a full body of medicine, and our patients and anyone who's experienced it realize there is a difference in our education and the level in which we practice. What we're really concerned about is just patient safety and making sure that the courses that will be taken for the dry needling are appropriate. There is a registry and appropriate course, approved courses for chiropractors and for physical therapists. That was done so that we're able to ensure that this is performed properly and safely. We as acupuncturists are the ones who actually have to deal with patients who experience the adverse reactions that are the ones who come and voice to us about what's going on. And they may not even complain because they don't even know they can. It's a totally different type of perspective about, how we treat. And we also know that dry needling is an established subset of acupuncture. It is that. Now, throughout all of medicine and healthcare, there is some crossover, as we've established. And so there may be certain things like cupping. There may be certain things that we all may use, like heat lamp therapy. And we have a subset here with dry needling that other professions want to perform. But I think we have to do due diligence to make sure that it is performed safely, that we also look at what are the courses that are being taken and that they're appropriate, because many of these courses are not. And we have tons of video on YouTube. You can go there right now where you will see the dry needling being performed, the lung being punctured, arteries being punctured, and it creates damage. So from that perspective, I think that, as individuals, as legislators, that we need to look at making sure that we've established clear-cut, established rules around how this is going to be performed, if this is going to be approved.
Thank you. I see Sherry Black has her hand up. Go ahead.
Thank you very much. I am a registered nurse and an attorney and a licensed acupuncturist and a member of the Maryland Board of Acupuncture. Our board still maintains that athletic trainers as a class do not have sufficient biomedical training to perform dry needling, which is an invasive procedure. And I noticed that this bill doesn't just reflect use of a filiform needle, but it also talks about other medical devices, and I'm not sure what that is leading toward. I think it was mentioned that 70% of the athletic trainers in the state of Maryland may have their master's degrees, but what about the 30% who do not? There's nothing in this regulation that requires a master's level to perform dry needling. So I question whether or not adding 80 hours on top of a bachelor's degree is really sufficient to prepare people to do dry needling, especially in a field environment. The people who are testifying are the elite of the athletic trainers. And I like the question about what about a high school athletic trainer? Do they even have a master's degree? What about an athletic trainer that works at some other facility? The question is whether or not they would be really adequately prepared to perform this invasive procedure. Also, I noticed that any kind of registration provision is not included in this, whereas physical therapists do have to have a registration, and the public can look up and find out if they are certified to do dry needling. So at a minimum, I think that this bill should require that the public have access to easy information about whether or not someone has been certified. And finally, and this I think is a technical matter, on the Senate bill, I noticed that there was still one section that talked about except as in subsection 5, F rather, which had to do with traveling athletic trainers. And in B3, maybe that's already been eliminated, but in the version I have, it still has that reference back to section F, which has been eliminated from the bill.
I'm looking at the clock. It's 12:41. I see Dr. Lynn Vance would like to speak, and we have a question from Delegate Lewis. I'm cognizant of my committee members who definitely need a break for lunch, so we're going to try and end at 12:45. So Dr. Vance, then Delegate Lewis. Go ahead, Dr. Vance.
Okay, well, in the interest of time, just briefly, I just want to say that as the experts in the use of a filiform needle, again, as Dr. Tyson mentioned, it's really not about a turf war. It's about the sheer volume of patients that we see that have confusion around the use of these needles, that have side effects from ill-performed procedures. And it's really about, for me, as a doctor of acupuncture, but also as a registered nurse, with understanding of proper informed consent, based on a lot of the testimony that we've heard from the athletic trainers and the way that they have misrepresented acupuncture practice and the inability to describe the difference between acupuncture practice and dry needling. I'm just very concerned about their ability to give proper informed consent. I also want to say I have my best friend of over 20 years God bless him. He passed a couple of years ago, but he was a certified athletic trainer. We went to acupuncture school together. He was the first president of the NATA. I have a great affinity for athletic trainers, and I wish that I had had the opportunity to work with them on this bill. So in the interest of time, I'll just leave it at that. But, you know, like I said, as a medical provider, I'm just, because it's an invasive procedure and does involve those more internal processes, your intent of using the needle does not keep the body from reacting the way it does when you use it. And so I'll just leave it at that and bow out in the interest of time. Thank you.
Okay, something you said was interesting to me, which is you wish you had had the opportunity to work with them on this bill. Do you think that there's common ground that could be found with a little more work?
Well, I'm not sure. I mean, the problem, I mean, it's been presented that we were contacted and we declined to respond. As the vice president of Maryland Acupuncture Society, I would have been the person to work with them. And I just didn't hear from them. So, you know, this, we were only made aware of this bill about 2 or 3 days before it was introduced. So a few short weeks ago. So it would be catch up at this point, but it's, you know, it's possible.
Thank you. Delegate Lewis.
Thank you, Madam Chair. Is there any reason why an athletic trainer can't just go get, take an acupuncture course and get certified like every other acupuncturist? If they want to do dry needling, is there any reason, any obstacle?
Well, an acupuncture program is a master's degree. It's a 3-year program. It doesn't happen overnight. So it's not like an 80-hour class.
Thank you.
Okay. We have, I think, heard from everybody on this, and it's 12:44. I promised the committee we would end at 12:15. So I, again, apologize to the stakeholders on 462 and apologize to the committee members for keeping you here late, but I'm glad we had the opportunity to hear from everyone on this bill. We're going to conclude this meeting, and thank you for being here. Sorry for running late.
Thank you.
We're adjourned.